Hey guys,
Hey.
Hi, Dan. How are you?
good. So we have a monster turnout. This is pretty good, guys.
I know.
Yeah.
103 people.
103 people?
That's how many people registered. We'll see.
Wow,
Well, it is.
that's exciting.
Very exciting. So you have people are gonna be in the waiting room. Oh no, people are joining now.
Yeah, I think I made it so that there's no waiting room.
Oh, good. Just turn my alarm off.
Dan, is that a background or is that your actual house?
It's not my actual house.
Okay, I was like, that's an extensive bookshelf you got there.
This is not real. Where am I? Yeah.
He has many leather-bound books, and his apartment smells of rich mahogany.
See, I had mine last time for Jake's for Loyola. It did not look this nice. So I'm like, you know what? This will make me sound that much smarter.
There you go. We'll give everyone a few more minutes, I guess, to log on.
Only 30 people.
I think it was all those TikTokers, Stephanie. There's just so many of them. They're just bombing the registration.
I know. We'll start in a minute or so.
For those joining late, this is not my real background, but it just looks super fancy. So just don't judge me. I don't have this much mahogany. Maybe like one piece of mahogany.
I was
No,
just
zero-
curious, Dan.
Zero mahogany.
Will Ferrell would be disappointed in the lack of mahogany.
Oh, listen, it's this life is young right now. I mean, maybe that's my aspiration. It's all mahogany all the time.
A man can dream.
All right. I guess we'll get started. If everyone could mute their microphones just to make it a little bit easier for everyone to hear Dan as we go through this. We're super excited about the turnout, although the TikTokers, as Dan said, might have gotten away with registering a few extra people. But my name is Stephanie Weissenburger, and I'm the Vice President of the Sports Law Society at New York Law School. I know we've got a few others on here as well, Emma, Darren, Josh. I wanted to introduce Darren and Josh also. They're the presidents of the Sports Law Society at New York Law School, and throughout they'll be monitoring the chat. If you have any questions, they'll more than happy to check the chat and interrupt us so that those questions can be answered. And then we'll also have 15 minutes at the end to ask any additional questions or make any additional comments. But we are so happy that Dan Luss is joining us today to talk all about the latest developments in the sports world. So I'll turn it over to him and tell us a little bit about yourself, what you do, your career path, and then we'll jump on into some of the hot topics.
Definitely. First of all, Stephanie, thank you for setting this up, everyone with New York Law School. Not so long ago, I graduated from Fordham Law School, not so far from New York Law School. I see Tony Iliastakis in the chat. We connected once upon a time. I, much like you guys here, I was super involved in my sports law forum. I ended up being the president of the Fordham Sports Law Forum. I competed in Tulane's baseball arbitration, and then I coached in it. And then by my third year, I created Fordham's basketball competition. So I see Jake Williams on here. He's the president of Loyola Sports Law Society. We did a Zoom maybe 2-3 weeks ago. As I mentioned then, I had no plan, and I still have no plan, but I figured I would just get as involved as possible in sports law society, sports law offerings, sports law competitions, and see where the world spit me out at. So I graduated from Fordham. By the time I graduated, I'd worked for the Giants for 4 years during college, during law school. I had moved on to a baseball agency, and then I got some actually really cool jobs working on the team side of arbitration. So for baseball arbitration, a lot of the teams do it in-house. They negotiate the contracts, and then there's, we'll say like between a third and a quarter that send it to these external lawyers that they want to, negotiate and do these arbitrations on their behalf. So I found my way there, which was a really cool job. And then when it came time for graduation, I'm like, okay, I have the super sports law resume. I don't really know where it's going to get me, but let's just hope for the best. I try to be pretty vocal about it. There's, as we can see, there's, 40 people in this chat. There are not as many pure sports law jobs as there is demand for it. So I learned that the hard way. And in hindsight, kind of being 2020, now being 7-8 years out of school, for every one of me that graduated as a 3L and really wanted a paid pure sports job, it was someone, like you guys now as a 1Ls, 2Ls, 3Ls to get this fantastic, wonderful experience. But the world was almost, we'll say cyclical, because it was just replacing 3Ls with 1Ls and so on and so forth. So that's, I guess, part one of the story. And then part two is I just kept networking. I kept going to events. I kept, really staying involved on social media. And then this whole sports law thing, as we'll get into, Stephanie, it's not really, sports law is not really a real concept. It's just different areas of law that intersects with sports. And I just kind of had this weird background in the law. I worked for a general practitioner. I worked for a former Manhattan DA. I worked for the Nassau County Attorney's Office. And then I worked for a large, two different big civil defense firms. So from criminal law to civil law to contractual law to employment law, I have a very weird base where I've for some reason or another practiced in a lot of different areas. And then at the end of the day, I'm just a really big sports fan, not afraid to write. I do a lot of CLEs on tech law, which is my other little thing. So I'm the president of the Westchester Bar Association's tech law committee. So I do a lot of CLEs on that. And now just kind of my writing in sports has gotten to a certain level where I don't have to talk about technology anymore. I can just talk about sports, which is a lot more fun. So Stephanie, I will turn it over to you. What's on the docket for today?
All right, so we'll jump right into it. I figured we'll start with the NBA bubble just because I just saw a notification from The Atlantic that multiple calls have now been made to NBA's anonymous hotline for breaking the rules of the bubble. So figured we'll start there. With the season beginning on July 30th, we've obviously already seen a player go out and cross the line to get a food delivery and things like that. What do you anticipate might occur as the season actually begins in terms of any sort of health issues and any illnesses, and how COVID overall is just going to impact this season, and whether it continues or whether at some point it'll have to stop?
So I got that same notification as you. It says a hotline is being used, and I'm like, oh, that's great. The hotline that they installed is actually being used for something. That's a fantastic headline. Yeah, so I think kind of as a backdrop, and Stephanie and I were talking about this offline, there's kind of this weird issue. The safer, of the four major sports, be it baseball, football, hockey, and basketball, basketball is definitely going above and beyond with the bubble, with these, titanium rings. I know football is making some progress too, but NBA is going definitely above and beyond. So the question is, and even with this, this tip hotline, we haven't really had any indication that exists in any other sport. As the law students on here and just general, people that understand kind of negligence law, duty, breach, causation, harm. In terms of your breach, you're not required as we'll say a venue, or as anyone like taking the care of individuals, to do the thing that's most perfectly safe in any given scenario. It just has to be reasonably safe under the circumstances. So the NBA, we're in an uncharted time. There's never been like what's reasonably safe to control all these professional athletes during a pandemic. There's just no bar. So we're kind of creating it as we go. So the NBA's creation of an NBA hotline for people breaking protocol, I think, is a really smart move. But what's to say that's reasonable? If Major League Baseball is not making a bubble, NFL is not making a bubble, the NHL bubble is a lot more lax. I don't know if any necessarily liability could result, but I think it's just kind of goes to show the NBA is kind of going above and beyond. If there's guys, I know someone got a food delivery. They went off campus. Someone, I think it's the Sacramento Kings. They're quarantined for 8 days. I know Kelly Oubre was posting on Twitter. He was like, here's the trick. If you don't want the food in the hotel, just get delivery. And then like everybody attacked him on Twitter. So it's a tough world. I mean, these guys are, 20, 25-year-old kids who, some of them are the same age as us. Some of them are going to be a little bit older. But that's the nature of the beast. So the NBA is taking on a very big ask by trying to keep all these guys under one roof. And they've kind of set the bar very high for themselves. So from let's say a liability standpoint, it's still going to be very hard to prove any type of COVID infection or liability, because again, duty breach, obviously the NBA has a duty. The breach of that duty is what's reasonable under the circumstances. But when I do these various, when people ask me on the radio and whatnot, causation is still this really, really tough element that you'll have to show that that the proximate cause of you getting COVID and even assuming you have a harm at the end of the day, that cause was particularly what the NBA did or did not do, as opposed to maybe you touching something in a hotel that wasn't necessarily under the NBA's control. So causation is going to be tough. And then Stephanie, the part that you and I were talking about, I think the safer the NBA wants to be, the more invasive they have to get in terms of kind of going into your data. So these titanium rings that will check your heart rate while you're sleeping. I mean, they're optional to some extent. But I'm not sure NBA players are so comfortable with, their employers knowing every nook and cranny about their biological clock. And I know that's been a separate kind of thing I like to research, is just where betting trends are going. We have like StatCast in baseball and a lot of just kind of advanced statistics. There's a world that I think the NBA is interested in, is selling private health data to books or statistics, and trying to use that data for betting in terms of heart rate or recovery rate. So I think it's an interesting slippery slope that the NBA is walking themselves into. Data privacy laws require them to delete all of this information, but the NBA is going to have it, and they're going to see how they can use it. So I think it's we'll say we're issue spotting here, but I think that's something to be mindful of. It. The NBA is going to have access to this data and see what it's like for the first time on a number of players.
Right, and sort of going off of that, how would you recommend they balance the privacy rights of these athletes while at the same time understanding that positive test results are obviously a big news item for fans and for the media in pushing out stories? How does things like HIPAA come into play, or other aspects?
So in my personal line of work, so I do a lot of civil defense. A good portion of that is defending personal injury cases on behalf of whoever. Whatever corporations are sued. So I like to explain it like in the McDonald's hot coffee case, we would have McDonald's, which in that case would be an interesting one. Most of my cases are not that interesting. We did have a Burger King case though, but that was a slip and fall, which also was not interesting. But when it comes to HIPAA is the general concept for those that don't know. It's to protect private patient information, and that can only be disclosed, if you sign the appropriate HIPAA form, or B, you kind of let the information out yourself. So for the first, we'll say 2-3 months of COVID, I don't think a lot of reporters had any concept of what HIPAA was. I know Shams over at The Athletic, he did an interview recently with Bill Simmons. He had no concept of what HIPAA was. So these guys were just reporting violations. I remember, so I think it was Rudy Gobert of the Utah Jazz tested first, and then it was Donovan Mitchell, and then it was Christian Wood. I'm probably forgetting one guy in the middle, but it was just name after name after name, and no one was saying that they self-disclosed. I think the first that acknowledged that they had self-disclosed was Kevin Durant of the Brooklyn Nets, and that was like 8 or 9 tests in. So kind of interesting, and for whatever it's worth, HIPAA only applies to medical professionals. So if you violate HIPAA, you could lose your medical license. You're not necessarily going to get sued by someone that doesn't create necessarily a private cause of action. But what we did learn, it's probably, I'm trying to figure out what year it is. It was, we'll say 3-4 years ago. Jason Pierre-Paul and the New York Giants, when he blew off his fingers in this crazy firework accident, Adam Schefter of the Giants somehow or another got a hold of this guy's private medical charts and tweeted them, which I'm not sure who wanted to see that. But they got out there. JPP sued Adam Schefter, and he sued ESPN for a tort that's called invasion of privacy. The money was undisclosed, but ESPN Schefter settled out of court because he invaded his privacy for no particular reason. It's not something that's so newsworthy, or where maybe a public health exception would apply. So I've seen it sometimes in my replies, and I have some of my my legal Twitter people that have joined the Zoom, but public health exception during a pandemic, maybe that's a relevant reason for disclosing someone's coronavirus diagnosis. But now we're in July, we're 4 months into the pandemic. Maybe it's not as an emergency as it once was. So I think for better or worse, these leagues have got a hold of it. I know in the NHL, if guys miss games, I think this is as a report as of Sunday, you're not even required to say why they're missing games. You could just say out, and there's no duty beyond that. Because I was curious before that news came out, if you just said a guy was out, parentheses, sick, what that would mean. I mean, everyone could be sick. So if everyone's sick, do I just think everyone has coronavirus at this point? I know there was a report from Roto World for the Houston Astros yesterday that said, 2 guys were out for undisclosed reasons, and it's unknown when they'll come back. And I'm like, that's pretty much code for COVID. But like, here's the best part. Like, I don't really know that. And that's why I think HIPAA is incredibly important, and incredibly important for guys like Woj, guys like Shams, to have people like myself and definitely some of the people that are on here to shame them in their replies so that they understand what HIP is, because no one needs to know who has COVID. If a guy is missing a game, that's good enough for me. I don't care.
Right, and then it actually brings in another legal issue. I know that obviously people over a certain age are saying that they might be at higher risk, and the NBA has been pretty cautious about that. Five of the 22 teams head coaches are 60 or older. How does the Employment Opportunity Commission kind of play into all of this? I know that if it poses a direct threat to their health that can't be eliminated by a reasonable accommodation, then how does this kind of all play in here? I know the WNBA player was also just not granted her request to opt out. So what are your thoughts on all of that?
So two things. The first one I've found very interesting. So there's 3 coaches, I think. So there's 5 over 60, 3 over 65, and that's Popovich, Elvin Gentry, and I'm going to know the last one. It's going to bother me. I'll think about it later. It's fine. But anyway, so there's 3 of them that are over 65. And, I think originally Adam Silver was giving indications that, hold on, Mike D'Antoni, I got it. Nobody told me that, so it's good. Just remember that. So, yeah, Mike D'Antoni does look like the Pringles guy. Just going to point that out there, just a random aside. But neither here nor there. So, being 65 years old, I think Adam Silver kind of noted, he goes, this may be 2-3 weeks ago at this point. He said that certain coaches aren't going to be allowed to sit on the bench. And he said, yeah, we're going to have to figure this out, but certain coaches can't sit on the bench if you're over a certain age. So that set off alarm bells for these coaches that said, hey, if I'm the head coach of my team, I need to be on the bench. That's going to put me at a competitive disadvantage. And just because I'm 65, it doesn't automatically mean that I'm, less healthy or automatically more at risk than someone that's 55 or even 40 or even like Elena Delle Donne, who's, she's the MVP. She's in incredible shape, but she has, Lyme disease. That's the MVP or the reigning MVP of the WNBA. So, I think there was some Rick Carlisle, who's the head of the Coaches Association, did some damage control with Silver and really got him to admit, hey, we're not going to cut off anybody at a certain age range. We're going to look at everybody on a case-by-case basis. The reason that was a very important, we'll say, backtrack by Adam Silver, if you were to cut off and make any type of, even if you're trying to be safe and say we're going to give coaches an extra test that are over 60, an extra test in the morning and an extra test at night, that's pretty textbook unfair age discrimination, because you're just picking an age and handing these people extra tests, even if you want to be safe. So just the general concept, and it's come up a lot during coronavirus. If you want to be safe and afford extra tests to older individuals, statistics show they're more at risk just generally, but it can't be required. You can't burden them. You can't force them to sit away from the bench. And you have to give them that option at the end of the day. So even a guy like Joe West, who's a veteran MLB umpire, he was designated as at risk, and he's still being given the ability to play. If you were to per se not let certain people in, then you're walking a little bit closer to ageism. And then, the news as of really late last night with Elena Delle Donne, Washington Mystics, MVP. I don't watch that much of the WNBA, but obviously I know who she is. Very decorated college athlete as well. She's on the defending champion team, and she's the MVP. If that had ever happened with Giannis or a version like LeBron, there would just be chaos. I mean, there would be like protests and sit-outs. And so for someone like Elena Delle Donne, who has Lyme disease, her personal doctor wrote her a note that said she's at risk. She has a right to sit out the season and get paid because she's at risk. I think it's bizarre that the WNBA, their panel of physicians, they said Lyme disease is not on the CDC's list of, at-risk disorders. So we're not giving her an automatic opt-out, so she can opt out, but she's not going to get paid. I don't know where the outrage would have been. I don't think any of us would have batted an eye if they made an exception for Elena Delle Donne, especially if it's Lyme disease and they just added Lyme disease to the WNBA's list. So, I'm curious, just as a sports fan, as someone that works kind of in this medical space, high risk is such a, we'll say, amorphous and ambiguous term. It's really open to interpretation. Anybody can be, at risk. I know Matt Boyd is a pitcher in Major League Baseball. He has asthma. He's calling himself high risk. Meanwhile, James Harden, who's on the Rockets, he has asthma. I don't know if either are high risk, and I don't know if the sports are going to treat that the same way. So when baseball was kind of floating around with this opt-out first, and they were using this term like high risk, still don't really know what high risk means if Lyme disease is not high risk. So, again, we're lawyers, contract interpretation. You always, Tony, you can correct me if I'm wrong here, but I think you interpret, contractual ambiguity against the person that drafted it. So high risk designation can really mean anything, but if you're not going to make the exception for Elena Del Don, my gut, and we're never really going to know this, but the percentage of people in real life, like all of us here, that are high risk, that number is going to be a lot lower inside these sports bubbles because leagues want players to play. They want to force that issue, which I don't think is fair. But again, these are private leagues, private entities, so they can kind of do whatever they want.
Right. And I guess going off of the contracts, we'll segue into Zion's big case that has obviously had a few developments lately. The big question here is whether Williamson unlawfully breached his contract with Prime Sports Marketing by firing Ford and then signing the CAA, and how much money Williamson owes Prime Sports and Ford as a result. But recently there's been new evidence that I know you've tweeted about, the McLovin tweet. I'll let you get into that. But just give us a little bit background about the case, and then the implications that obviously Gina Ford, the president of Prime Sports Marketing, may be facing as a result of the evidence that you'll get into, and anything like that.
Okay, so this is not the cleanest case from a procedural standpoint. Stephanie did a good job giving the highlights, making me do the heavy lifting. I appreciate that. It was very nice of you. So there's 3 cases, but we'll only get into 2. The third one's not that important. The third one's about a finder's fee that this agent's trying to get, but we can leave that one aside for now. Zion Williamson, superstar, #1 overall pick for Duke. He, I guess important, he grew up in North Carolina, born in North Carolina, grew up in South Carolina. And when he was trying to figure out a venue to sue, he went to Duke, so why not pick North Carolina? So he filed suit in North Carolina to get out of a marketing deal that he had signed with Prime Sports Management while he was at Duke. So if anyone's kind of having pause and you're asking yourself, wow, Zion signed a marketing deal at Duke, he 100% did. He's 100% owning that, which is kind of bizarre. Nobody knew about it until after he'd already left. So there's a rule, or there's a law in North Carolina that if you were our student athlete, it's kind of like the same law that we learn in contracts. If you're a minor, all contracts are voidable, but you can assent to them once you hit the age of majority. Same concept for Zion. You're a student athlete, and you're an amateur athlete in North Carolina. Every contract that you sign is going to be voidable. So, once you're no longer a student athlete, once you're no longer an amateur, you have the right to void that contract. So when Prime Sports Management, a company run by a woman by the name of Gina Ford, has no real basketball ties, but does, at least did at one point represent Usain Bolt in the marketing sense. So she does have some clout. She signed a very one-sided deal. It was very favorable to Gina Ford and Prime Sports. It was basically like a lifetime marketing deal. It gave basically the marketing rights for her for eternity. So A, it was a bad deal, and B, it was with kind of an unknown. So when Zion signed his CAA sports contract, CAA, a mega basketball entity, mega sports entity, they said, you know what? We kind of want you to get out of this deal with Gina Ford. We've looked over the contracts. We had our high-powered lawyers look at it. We think you can get out of this. You're going to have to file suit to get out of it, but we think you can, just a declaratory judgment, get this thing null and void. So Zion files suit. We'll say it's his home state, North Carolina. He's from the Carolinas. And then Gina Ford turns around, doesn't file a countersuit. She files a separate lawsuit in the state of Florida for breach of contract, which is just, she's saying that Zion didn't have the right to void the contract. Okay. So we have 2 separate lawsuits. And just kind of a fun footnote, in that Florida case, Gina Ford's also suing CAA for tortious interference with the contract, because in theory, she told Zion to breach that contract. So put the Florida one aside for now. We're only in North Carolina because Zion got a stay against him in the Florida case. So Zion really only cares about North Carolina. Zion filed a motion there in North Carolina. It's called judgment on the pleadings. New York will know it as summary judgment. And he filed a motion. He said, you know what? I don't think you have any evidence to hold me in this case. You're going to say that I, for some reason, don't have the right to exercise my ability to void this contract under North Carolina law. So what Gina Ford argued back, and she's been kind of saying this consistently, whether or not you buy it, she's saying that Zion, because you accepted benefits before we signed our contract in January of 2019, you didn't have the right at that point to be considered a student athlete. You accepted some benefits beforehand. So her evidence of that is kind of like smoke and mirrors. She points to in this, so Zion filed for motion, his motion for judgment on the pleadings. She opposed it with, excerpts from a conversation that a Nike executive was having with someone at Duke that, or someone, I think it was a runner, but, Nike's going to pay to cripple Adidas. And then a wired conversation between a Kansas Jayhawks assistant coach that, Zion's dad asked me for 6 figures. So all kind of smoke and mirrors. But that was really it for her opposition. So, you have to show a little bit more. If you do have a smoking gun, that's the time to bring it out. Otherwise, Zion's argument and what he said in his replies, this is just a fishing expedition. This is all smoke. It's all speculation. They have nothing that would show I'm not a student athlete. And beyond that, I was playing games all the way through March Madness. I dunked on Taco Fall. I was a student athlete. The proof is in the pudding. So that was his argument. He goes, it doesn't matter what I got beforehand. I played the games. They didn't find out of that, which I kind of buy. So that being said, motion is marked fully submitted. It's sitting in front of the judge. Me and my co-host on my podcast, which I should plug quick, Conduct Detrimental, the sports law podcast. Dan at Wallach has been we've been on top of it, we've been talking about it, but we said this case could get dismissed any day because I don't really think she met her burden in opposition. Okay, so that brings us to lovely Thursday of last week when Gina Ford ran. She didn't run to the courthouse because we're in a pandemic and we can't go outside. But she proverbially ran to the courthouse and said, stop the presses, don't make a decision on this motion. Here is some new evidence that I found. The general gist of it is that Zion, before this, they signed their contract in January 2019, that Zion got a very favorable loan, $400,000 loan from some very shady characters. But she had someone, the guy that set the deal up had a sworn affidavit, a California lawyer. He was swearing up and down that he set these 2 people up, and they submitted the loan agreement. And in addition to this loan agreement, again, they had Zion's signature on it, his stepfather's signature, and also what was submitted as part of this kind of new evidence filing was the ID that Zion, we'll say he gave in to verify that he was actually Zion Williamson. So in theory, right, again, you might just, he dunked on Taco Fall in March, so maybe he was still a student athlete. You can buy that argument. This doesn't matter. If you're on Gina Ford's side, hey, this guy got an improper benefit before he signed this deal. He's technically no longer a student athlete. In that world, this piece of evidence is super, super important because that could divest Zion of student athlete status. So, Stephanie, do you have any takes on what this newly discovered evidence looked like, or if it seemed like legit or anything like that?
Well, in addition to, you didn't mention that the attorneys had already mistakenly subpoenaed a dentist in Indiana.
I forgot that.
Instead of the NCAA. So I think that already hurt their credibility to begin with. But yeah, the ID was straight out of Superbad, honestly. Everything was messed up.
I 100% agree. I'm not from South Carolina. I'm from New York, so I don't really know what a South Carolina ID is supposed to look like. But the lovely population of Twitter decided to just, Zion dunks on Taco Fall and Twitter dunks on Gina Ford. And they just went to town on this ID. So I guess if you're under 21, your ID is supposed to be vertical. This is horizontal. Zion's middle initial somehow got lost during this forgery. He just didn't have one. Instead of Williamson Zion, it just said Zion Williamson, no middle initial, because driver's licenses don't have middle initials. Height and weight was flipped. 3 digits on the zip code were in bold. And then my favorite, which I don't think he's here, the guy that pointed it out, but someone pointed out that the South Carolina governor was listed incorrectly on the bottom right corner of the ID. So this is just Twitter at its finest. Dan Wallach and myself happened to catch it early enough and just kind of put it up and just said, what do you guys see? What looks wrong with this? Twitter really went to town. So Stephanie, to your point, if this is a case where I felt really comfortable about my chances of successfully opposing, I'll call it summary judgment, but it's judgment on the pleadings. I'm probably just going to sit tight. This thing that crosses my desk that looks really suspicious from a really shady character. If you just do a couple Google searches of him, he's really shady. I don't want this guy anywhere near my case. It is absolutely nuclear. But to make the decision to use this and then to give it to, I guess they gave Zion a chance to look at it beforehand. They told them it's a forgery. It's very clearly a forgery. Just my favorite response in the whole case, Gina Ford's attorney says, well, you haven't given us any evidence to show that it's a forgery. So we're gonna go ahead with this. So not the smartest, but I think just objectively, if you really felt good about your chances, this would be nowhere near your arsenal. You would not touch this. It would be absolutely radioactive. And their willingness to use this might seem to show that they felt that there was a decent chance they were going to actually lose on this very early motion for judgment on the pleadings, which we thought, but not really the best sign. And I think in a higher level, we have a lot of attorneys obviously watching the chat now. Just pretty textbook. If you knowingly use just forged evidence, or you knowingly commit fraud as an attorney to bolster your case, that's the worst you could possibly do. That's sanctions, that's potential disbarment. That's really bad. So, obviously there's a motion now pending to see if the judge will accept this newly discovered evidence. So, there's obviously a slim chance the judge allows it in and allows a fact finder, be it himself or the jury, to assess the credibility of it and let it in. And then there's a separate inquiry that's going to probably go to the Florida bar or wherever these guys are barred, be it North Carolina, as to whether or not they knew this thing was a fraud. So, you never, as an attorney, want to wish any kind of reprimanding on someone, but if you're going to use this thing, which, all of us, we had a lot of fun dunking on this license and how obviously it was fraud, you had to know as an officer of the court that there's something suspicious about this. So important to pay attention to. I've had stuff that's weird come up in my cases. I always want to see who the source is, how it's coming to you. But on this, on a super, super high profile case, you really have to know better than that. And so, it is what it is, but it's looking better for Zion today than it was this time last week.
I think going off of that, we can kind of segue into the DeAndre Baker and Quinton Dunbar case. I don't know if anyone really has been following that one too much, but a few months ago, the two were attending a house party in Florida, and there was an alleged robbery of 4 victims where they took $12,000 in cash, $25,000 in watches. Baker allegedly took out a gun while Dunbar and another man started taking valuables. And then all 3 made off separately in their very nice sports cars, not exactly the types of cars that you'd think would be getaway cars, but it seemed like they were going to be getting off on this because 5 witnesses had signed sworn affidavits that exonerated them from any involvement. But recently it came out that there might have been potential payoffs in getting these witnesses to falsely make their statements. So I guess my first question would be, similar to the last, what kind of implications may Dunbar's attorney, who knew about the payoff, was involved in it, what could he potentially be facing, and where does this case now go from there?
That was a very good segue from unethical lawyering to potentially more unethical lawyering. That was very logical. It's a big case, obviously, in New York, but it's just another important case as attorneys. And anybody that's kind of just watching, the news, you have an obligation as an attorney to kind of vociferously defend your client. If you're making a comment to the media, you want to make your case sound good, encourage public sentiment. This case was a little weird. It set off a couple red flags because there were attorneys that were for DeAndre Baker of the New York Giants guaranteeing dismissal within the week. Saying with charge against gets dropped, it's a matter of time. So you only say that if you have an absolute home run of a case. Otherwise, you're just kind of poking the bear, so to speak. You are telling the prosecution and the DA and the police that you don't believe in their case, which is not something I would personally do in any of my media take cases. So that being said, what happened here, we had four witnesses, four victims and one witness. I'm not sure. I think it was a Saturday. Maybe it was a Friday. Maybe it was a Saturday. But in any event, within 48 hours of them signing sworn affidavits saying who they felt had the gun, be it Baker. Baker was charged with more significant charges than Dunbar. Within 48 hours, story would have it, according to Quinton Dunbar's attorney, that all five of them showed up at his office. And they said, we're ready to recant our story. We know it's a pandemic. We know we're not allowed outside, but we're all here. We're all together. Don't have to pay us a nickel. We just want to change our story, which sounded bizarre. It sounded bizarre to everyone, but, stranger things have happened. There's also, I watched this great documentary on Netflix with the Central Park jogger case. Sometimes there's going to be a sworn affidavit that's suspicious because it was coaxed by the police. So that's where Twitter seemed to fall. Twitter seemed to say, hey, the police probably pressured them into saying this. But no matter which way you slice it, definitely suspicious one way or the other. So now, unintentional now plug of my podcast, there's a guy, Pat Leonard, the New York Daily News, who broke this story on Friday night. He basically filed, and you guys will know this as attorneys or law students, a Freedom of Information request to just see what was in the DA's file. He just, on a random whim, sent it down there. Maybe he sent it down there a couple weeks ago. It just got satisfied. So this guy at the New York Daily News happened to be the first one to find out that Quinton Dunbar's attorney was under investigation in Florida for committing fraud or maybe inducing people to lie under oath. And then I guess they have witness statements, but on top of that, they have closed circuit television apparently capturing all of these little moments where someone brings a bag of money into the office. All five witnesses are gathered kind of outside, and money is being exchanged out of the bag. The transaction is done. We'll say transaction, literally the five exact people that had this sworn statement, they're all at this lawyer's office. They're all being like, almost as if there's like a bag with a money symbol on it, just being handed money here, money there, everyone gets money. And then we see their affidavits now. They are literal cut and paste versions of each other. They're identical. At 3:15, at least according to this warrant, CCTV says the transaction is over. Everyone goes their separate ways. The lawyer goes back into his office. And then 45 minutes from that is when the lawyer contacts the detective and says, hey, I got five affidavits and they all contradict the other one. So again, these are all allegations, but when they're backed by CCTV and especially just the progression of this lawsuit, I'm sure, again, just kind of going back to kind of what I said up front, when you make a guarantee that a case is going to be dismissed, and I think Dunbar's attorney I think they said he was, he was just really bragging that a case was going to be dismissed. He's demanding a dismissal as well. You're going to have the prosecution. They're not going to want to look stupid. They're going to pour resources into this case. And now the tides have completely flipped. And, Stephanie, you kind of pointed to it. If those affidavits, the five ones we had originally, were just directly contradicted by a later affidavit, maybe there's some version of perjury that went on with these witnesses. But when it comes to Dunbar and Baker, the burden is on the prosecution to prove proof beyond a reasonable doubt. And all they have, at least as far as we're aware, is the statements of five individuals. So if you all of a sudden ruin the credibility of those five individuals with completely conflicting affidavits, all of a sudden those witnesses have no real viability to the case. The prosecution's not going to touch them, and the case could get dismissed. But now we're in this really weird, murky waters where the witnesses have allegedly lied under oath, were paid, and the lawyer could be in trouble. I don't think the witnesses are automatically, corroborated, or they're not. You don't automatically rehabilitate them because they were paid. I still think there's an issue for the prosecution to prove their case. These witnesses are going this way, they're going that way. I think really the biggest development is going to be for the lawyer, and that's the whole Quinton Dunbar's legal team dropped out. They withdrew from the case. That's really where the development lies. I don't know if this actually really helps the prosecution's case that much. I think the witnesses are still really bad, but the lawyer is going to be in a lot of trouble, and probably more trouble than we're looking at in the Gina Ford case.
Lots of unethical lawyers here lately.
None in this chat. None in this chat.
I hope not, as far as we know. Let's get into the nice parts of the NFL lately with Pat Mahomes' new monster contract. negotiated by Lee Steinberg. He signed a 10-year, $450 million extension, which totals 12-year, $477 million contract with up to $25 million more in unspecified incentives. But with the uncertainty of Corona and how the salary cap changes year to year based off of revenues in the league, what are the biggest aspects that you see of the salary cap rules and how they impact teams, especially the Chiefs in this sense? And what do you see for 2021 and how they're going to be able to continue being successful with all of the money that they have now spent on Mahomes?
So just coincidentally, the Chiefs also had another mega signing today. So they've spent, that's Jones. So they spent about $100 million between the two guys. So the Chiefs might know something that we don't because they're spending money when no one else is, which is just interesting. I mean, they're the Super Bowl champs. So, I mean, you know, if you're doing something differently than people, you're either very smart or you're very dumb. But, you know, the Super Bowl champ. So I don't, who am I really to question them? The only thing to point out, you know, we are still in a very much of an unknown. The Chiefs, as much as, and I try to say this as much as I can, if anybody tells you they know exactly what's going on with this pandemic, they are just guessing. You can't, even if it's the guy at the highest level, someone like a Tony Fauci, even he doesn't really know exactly what's going on. I think everyone's just guessing at this point. You know, a couple months ago, Adam Schefter was very vocal that if there are no fans in the stands at all for the NFL season, that the cap could drop anywhere between 30 and $80 million. So that is a massive, massive hit. Now, as we're getting closer to showtime, the week one of the preseason is going to be August 20th. It looks like we're going to have at least limited seating. I think the Ravens are on record they're going to be about 1/5, 1/6 capacity. And that seems to be the general sentiment. Maybe some states can't have any fans at all. But even a state like, you know, Maryland, they're going to go with 1/6. I doubt we see any full stadiums, at least anywhere in the beginning parts of the season, if at all. But you know, that being said, the cap makes up about 15% of the NFL's total revenue. So if you were to, you know, let's say you have 20% capacity in all stadiums for the rest of the season, you're going to lose about 12% of total revenue. So you lose 12% of your cap. That's a very, very big number. And you know, when it comes to Pat Mahomes, the reason I thought it was a home run deal for Pat Mahomes, if you know, and I'm not sure many people, I listen to the Ringer NFL podcast. It's a very good podcast. It's not my podcast, so I'm plugging that. I feel like that's fine. But they were very, you know, I listened to them and I disagree with them, but they said this is a fantastic contract. Mahomes really isn't getting that much money. It's going to be a really affordable contract, assuming the cap continues to stay normal. And I'm like, well, you know, I don't know why we're assuming that the cap is going to stay normal. That's just not the case. The NHL, just for example, the NHL has an $81.5 million cap this year. Before this COVID, they were supposed to have a cap that was supposed to go up to $86.5 million, but they've changed course and they said our cap is actually going to stay directly at 81.5. And that's the NHL that's finished 80% of its season, a normal season with normal revenue. So for the NFL to say that their cap is going to go up, I mean, it's just as likely that it goes down if hockey stayed the same and they basically had 80% of a normal year. So then the question, guys, and this is for all of us, which we're all still going to have to figure out in our own sense. And I know, Stephanie, you and I were talking about this, and I mean, it's everyone's own risk tolerance. There are going to be waivers at sporting events for the foreseeable future. And that's for the athletes to sign and be in college. And I'm sure I'm happy to get into that. But for fans, it's just, you know, you go on a bachelor party and you go whitewater rafting, you have to sign a waiver. You go skydiving, you sign a waiver. And now in the middle of the pandemic, you're going to have to probably sign a waiver to go to any type of sporting event. The question is, you know, not just for this year, how fans will react if waivers and COVID kind of lingers. You know, there might never actually be, you know, some type of cure, complete 100% cure. Just we can't guarantee that. So if there are waivers into 2021, 22, 23, how does that impact revenue for the next 3-4 years? And then how does that affect the cap for the next 3-4 years? So originally, as Adam Schefter reported it, which I was, you know, I like dunking on Adam Schefter. I think he's a good guy. But you know, if I can dunk, I will dunk. I'm not Zion, but you know, once in a while I get my dunks in. Schefter reported originally that this mega contract was going to be tied to what the cap was, and I thought that was really, really smart because if the cap goes up, let Mahomes make a ton more money. Let him be around 25% of the cap. Right now, he's going to be around 22% of the cap, but let him make more. And if the cap goes down, I think that would be fair for Mahomes to agree to. He gets the long-term stability of a 10-year contract. It's always going to be 25% of the cap. That seems very fair. And then Schefter retracted that earlier report and said it's not going to be tied at all to the salary cap. So you just have a world, yes, NBA ringer, NFL ringer. If the cap stays normal, it's a great deal for the Chiefs. They lock Mahomes in for eternity. But if it goes down, all of a sudden, Mahomes taking up 20% of the cap, which is still a huge number. Stephen, you and I spoke about this offline. If that number becomes a third of the cap or 40% of the cap, you've just crippled your team. And maybe you're fine because you have Pat Mahomes and he's the best quarterback in all of football. But, that's not the bargain that you signed up for. And all of a sudden, this deal becomes an albatross. And then I guess the only thing I'll say, I don't know in the history of sports when a 12-year contract has ever looked good. I remember Rick DiPietro for the Islanders had like a 20-year contract. That looked bad after like 2 years. So Pat Mahomes is great. The NFL is a contact sport, and guys get hurt. So there's a completely non-salary cap reason that this deal might not be so smart. But as attorneys, you got to give credit to his agent. He got a really good deal, and he struck while the iron's hot. I don't expect to see any deals close to resembling that for be it Dak or Lamar Jackson or anyone like that.
Awesome. And we're running a little bit out of time here, but I want to make sure that we get into the Washington Redskins name change a little bit, just because there's lots of intellectual property issues associated with that one. So although Snyder has always said that he would never change the name, they just announced yesterday that they will be changing their name and logo. And while it might be a while before the Washington team officially has a new name, they might have some roadblocks to overcome, because Martin McCauley, a 61-year-old, has filed 44 trademark claims on potential new names for the Redskins since 2014. So if you could just go through kind of what the Redskins are going to be facing with this and how they might be able to get around this if he has one of those names that they're looking at.
So I'm pretty sure you called him Martin McCauley, but I feel like his first name is Troll McCauley, because he is a long-term troll on the Redskins here. So Mr. McCauley, I looked, I saw his name pop across Twitter on Monday morning at about 40 followers. So he's up to around 250 now. So he was quoted by Barstool. They had their own sit down with him. So he's getting his nice publicity. 6 years ago, right around the time that South Park episode, that lovely episode came out, when the Redskins lost the trademark, right around then he said, okay, I guess the Redskins are going to change their name. And Stephanie, as you pointed out, that was also around the same time where Dan Snyder said he was never changing the name. But Mr. McCauley did not buy Snyder at face value and continued to pick up trademarks, including the Red Tails, the Red Wolves, a number of names. I think the Washington Monuments, all these crazy names. The guy spent a lot of money, and he's trying to, I guess we can get into what his motives are, what he's saying versus what we actually believe. But I guess in a very short sense, the time frame is very interesting. We're mid-July. The season is going to start on August 20th. And the Redskins, just as a strategic move, if you're the general counsel of the Redskins, you're probably furious because you spent the last 6 years defending a trademark, which literally has no value anymore. So that's, I guess, step one. But number two, you are now going to have to go through all these trademark hurdles. You've announced that you're changing your name without having secured the name. So all of the names that you might have wanted, be it Red Wolves, Red Tails, Snyder was trying to get an Arena Football League team at Washington at one point. He was going to call them the Washington Warriors. So that's, if anybody's betting on one of these offshore books, not that I am recommending it because that's illegal, Tony. So don't. It's logical conclusion here. Washington Warriors. It's not like I'm betting on that. I'm not. So but that being said, that was a very we'll say not the smartest move by Washington to announce that. Just didn't really make any sense. We knew they were going to change the name, but not the smartest. So what McCauley has done, it's very interesting. And we had on our podcast yesterday, we had Darren Heitner, who's like the sports trademark guy. And we wanted to get into an understanding of these timeframes. So it's July. I didn't think it's possible for them to get the trademark done by August, and it's not. Absent any type of disputes, trademarks could take 5 months to get done. And there's some reports that that Snyder wants a name that's currently in a trademark dispute. So whether that's he's talking about Macaulay or there's a separate battle going on at Arkansas State with a different trademark for the Red Wolves, whether he's talking about that, this is going to take 4 or 5 months. So Macaulay's going to delay it. Again, I think he's been pretty on the record that he's not going to defend these. He just really did it to, I guess, make sure someone worse than him didn't get it, which I don't really know if that makes sense. But he I guess wrote a letter to the NFL last weekend, said he's ready to give up these marks if someone just writes to him. But he has not heard back. And so we're going to have a scenario. There's really no way to get around it. Come August 20th, whatever the name the Redskins use, they're not actually going to have that trademark, which isn't so foreign to the Redskins because, again, back when the South Park episode was going on in 2014, they had briefly lost the trademark protection on that right because it was ruled that the Redskins were just a name, a word that just was harmful, that you couldn't have a trademark. So they played without a trademark, and come the 2020 season, if we do have one, fingers crossed, they're going to be playing again without it for a period of time. So even though it's unlikely, there is a scenario where the Redskins pick a name, let's say it's the Red Tails, and then they suit up for their first preseason game as the Washington Red Tails, and they lose this trademark battle to some, first and right, and all of a sudden they're the Washington Red Wolves by the end of the season. So as crazy as it sounds, the Washington Redskins have messed this up enough. Don't count out more screw-ups on their part.
I know I'm from Washington, but a Giants fan for good reason, clearly here as well.
That's good.
I guess we will move on to questions. If anyone has any questions to ask, I know we're running a little behind, but that's okay. We want to make sure we get any questions in. If you have any questions, feel free to unmute and just ask away.
I have a question.
Oh, go for it.
I'm sorry about that. I wrote it in the chat. So I know there has to be some level of commerce needed to defend a trademark. So it's not just these squatters getting away with fake marks. What level of commerce needs to arise to defend that? He has an active store with random cups, mugs, shirts with the names on it. It seems like it's a front, but so where do you need to get to in order to defend it?
So Jason is president of Hofstra Sports Law Society.
Vice president.
Well, your president's in there. It's fine. It's a very good question. There are a couple of these marks that he's actually gone out and, whether he bought a certain amount of mugs and put them out into the stream of commerce, that is definitely a requirement. In addition to just buying the mugs, you actually have to sell some mugs. You can't just have them up for sale and have the complete front. I think one of the baseline levels is to have a website and have we'll say an avenue or a venue where people can actually buy your product. But at the end of the day, I think we can all see through this that it's a sham. And there's squatting laws. If you do something that's clearly resembling squatting, that they're not going to, account for it. But the problem is, and I guess the good thing or the bad thing, Macaulay says he's not going to defend any of these marks. So if anybody challenges him or challenges the legitimacy of it, he's going to, let them go. He's just a 61-year-old guy with apparently way too much time on his hands, registering 40 marks, including the roasted nuts, which I had a lot of fun with. I think that's a fantastic team name if I could pick one. But yes, you definitely need the commerce, but I think it's a moot point here, Jason, because he's not looking like he's trying to defend it.
Great, thank you.
Go ahead.
I want to go back to the way beginning of the conversation. You were talking about the biometrics that the NBA created the rings for, and I think the NHL is creating something to stick in jerseys, whatever. And since you're the tech sports guy, I think you'd have the right answers to this. One, who would technically own that information, and do players have any rights over it? And second, I know that all the players' associations are doing their best to keep that out of the realm of negotiating when it comes to either contract negotiations or CBAs or whatever. How do you think that's going to work out?
So there, and this is obviously something I'm very curious about. There was a lawyer, a tech lawyer from Pittsburgh, a guy named Derek Maltzby, who's not in here, but I think he's going to end up writing an article on it. And I implore, as Jake, Jake's president of the Loyola Sports Law Society. I implore everyone to write. I think that's the best way to get out. Stephanie, I should give you a shout out too with the Full Court Legal Press. I know you have your own blog out there as well. So Jake, to your point, I think I mean, I know in terms of data privacy, you're not really allowed to keep this data for in certain states. So be it Illinois is one of these really heavy states. You can't manipulate this data in any way, shape, or form, or else there's a private right to sue you. It's a private actionable right. If you manipulate someone's data, use it improperly, be it retina scans, you could get sued by these individuals. So there is a conspiracy theory out there that this is why the NBA looked at Florida, because they could use all of this data and they really couldn't get hit with any lawsuits because there is no biotechnical data privacy laws in Florida yet. It's pending, it's on the books, but it's not really in play yet. So the NBA is going to have this data. I believe there's going to be certain medical officials that are going to have it, and certain, I guess, just bubble people that are going to have it. Be watching. I know, just kind of an interesting aside, there was a golfer, I'm not going to remember the name, but a golfer had this special, I guess, waistband he was sleeping with to track his breathing protocol. And he figured out that he had COVID because he woke up the next morning and he noticed an irregularity in his breathing while he was sleeping. So it's proven that these types of technologies can help COVID. The problem is, is for me, let's say I'm, hypothetically, of course, let's say I like to bet on games every once in a while. Would I want to know if someone had a good night's sleep the night before? Like, that would probably be relevant to my decision. And if that's relevant to my decision, it's going to be relevant to bookmakers and sports books. And they're going to put and NBA spends a lot of money with DraftKings and all these different partners, be it MGM or even PointsBet, the new partner of the Detroit Tigers. So the NBA is not, I mean, Jake, they're seeing the same issues that you and I are. This is going to be data that they can make a lot of money off of. So I 100% expect this to come up in the next round of negotiation. I mean, I remember when baseball was going back and forth with the union, they were talking about whether players should have live mics on the field. That was one of these negotiating chips. Invasions of privacy, I mean, that's probably a little less invasive than a data chip, while you're sleeping, but it's in the same spectrum. So players are using that as a chip maybe to get more favor on their end. They said, we're going to be live mic'd while we're playing. We're happy to do that. So the logical extension of that is more data. So it's not just StatCast data, how far the ball goes off the bat or what angle it's going off of. It's going to be what their breathing rates are, what their recovery rates are. They're going to have it. It's going to be in control of the NBA, and they've acknowledged, I think it's, don't quote me on this, but I think it's like 6 months after the season, they have to get rid of it, and they cannot keep it on file. But that's wasn't really required of them under Florida law, which didn't really have anything on the book. So I would look out for it, but these leagues, I mean, if there's more money to be made, if it's the NFL adding 2 more games, if it's the NBA potentially trying to sell your private data to betting partners, you definitely cannot rule that out.
Professor Tony, I never thought I'd be calling on my previous IP professor, but do you have a question?
First off, nice seeing you, Dan. It's been like 6 years since we last saw each other. Dan's studying for the bar exam when I was a vice president at the Sports Law Society at New York Law School. So it's nice that we kind of like flip the pages. I was the sports law media guy, and now you took over the helm, and rightfully so.
I'm just following in your path.
Right, exactly.
I'm law and batting order.
That's right, exactly. Channeling your inner law and batting order. I'll keep it brief because I know that you guys are running low on time. And Stephanie, and to you and the Sports Law Society, fantastic job with this talk. Dan, I know that you touched on the Redskins trademark registration running its course beginning in 2014 when it lost the registration because of the disparaging term, and that's all based on the Lanham Act. And it actually, I think it kind of had its run where ultimately the decision was vacated in 2018, where the courts agreed that it was disparaging, but they reinstated it. But it was kind of like a moral win for the Native American population and a win somehow for the Redskins. But now we're kind of back at square one. Redskins are without the trademark. My bigger question is actually more relating now, the focus shifting towards all the other sports teams that have some type of origin to Native American roots. So the Chiefs, the Indians, and actually specifically the Indians have Chief Wahoo as their mascot, although they've slowly drifted away from that. I guess my question is, for any other teams that have this Native American moniker, could we start seeing the PTO invalidating those marks potentially for this disparaging point of view that they had for the Redskins back in 2014? Or are they going to voluntarily just abandon the mark more from the moral point of view?
So it's funny. So people were, before the Redskins had this announcement on Monday, people were asking what could force the Redskins to eliminate the mark, and I go, well, I mean, the legal thing that was going to force them to eliminate the mark was the trademark, but they didn't really care. They just kept going on with it. So money talks, and it's advertisers, and advertisers are pushed by public sentiment. I've been pretty, again, hindsight's 2020. I wasn't caring so much about the Redskins situation. Wasn't necessarily on my radar, but in hindsight, you think about it, Snyder, if he would have done this last year, just on a whim, he would have been championed. Everyone would have been so excited. They could have had Twitter polls as to which name to pick. Now it's almost a lose-lose scenario. It's a lose because he was forced to change the name because of advertisers, and it's a lose because he's pushed by money. But I guess like a lose because now Martin McCauley is showing that he's much smarter than the entire Redskins legal team. But neither here nor there. I think I think the general gist, and depends how far down the rabbit hole you want to go. So there's the Indians, I think, are the next logical one. Terry Francona is already saying that he's in support of a name change. And then where do you go from there, right? Do you go to the Braves? Do you go to the Chiefs? The Warriors technically are have Native American tones to it. So, I mean, it's tough. I think for the Redskins, I think as we've seen now, you call them whatever you want. I mean, if you win games where people are going to find you, it's not like you're switching cities. It's not like you're going to lose your mark or lose your standing in the base. Like the Golden State Warriors, if they're winning, championship after championship, you can call them whatever you want. People are still going to go to the games. But I think probably the closest example we'll have to this is maybe the Washington Bullets, not so long ago. Not the nicest connotation, the Washington Bullets. They changed the name to the Washington Wizards. I don't think any of us cared. I think it was just totally fine. So if you're, and the Bullets had a long history. They had a lot of big names go through the franchise. The Redskins have such a checkered history in public sentiment. I think it would have been really smart for Snyder to have done that. Obviously, he wasn't going to. But when it comes to the Hunt family in Kansas City, or the Braves, those are franchises that haven't had that many issues with PR. So I don't know. Maybe you wait until there's public sentiment that's really brewing. I know the Indians are really probably next in line, and then the Braves. I think on a standpoint, you have to kind of balance how much money you stand to lose by losing the history of it. I mean, Tony, you pointed it out. Chief Wahoo, I know the Indians had some hesitancy to getting rid of him as their logo, but you can go on eBay or any type of store online and get merchandise of Chief Wahoo. It's not that market doesn't really go away. So you have to ask yourself how much money you stand to lose by not changing the mark versus how much money of fans leaving you because there's because they're protesting the Atlanta Braves outside the arena. So it's going to be a gut call. I think if people are watching the Wet Redskins situation, they could not have handled this worse. And Stephanie, I'm really sorry. I know you're from Washington, but they just botched every angle of this imaginable, including the trademark. So yeah, I don't.
Hockey and now baseball, so we make up for it.
You guys are Washington Nationals are the champs, though, so you do have that. But yeah, I think if you're watching the Redskins situation, you want to get ahead of this. At least, Tony, at a minimum, start registering some other names now before the gun's to your head and you're stuck fighting off Martin McCauley trolls.
Sorry, I had to unmute. I was going to say, if I had to place a bet on a name, I actually think they're going to change out of the Washington name entirely. I think they're going to go DC.
I've heard that.
I think DC president sounds pretty enticing.
I could see.
Cool with that.
Any other questions? Anyone? All good? All right, well, thank you guys so much for joining us. Hopefully we will have another one of these in the future and bring Dan back. It's been awesome. Thank you so much, Dan, and thank you all for joining us.
My absolute pleasure, guys. A cheap plug, Conduct Detrimental Podcast, myself and Dan Wallach. We had Darren Ravel on last week. We had Darren Heitner on this week. We do get some big guests and sports law. And then I guess there's one final note. Stephanie and Emma, I'm not sure who else. I know Jason and Jake. Jake, do you want to give a little plug to the Student Sports Law Network?
Oh, yeah, that's a good idea.
Did we lose Jake? Oh, we lost
He
Jake. Oh
left.
man. Oh, he's gonna get bad marks. I'll plug it for him. So I've spoke to a number of people in this chat. Sports law, it's only as much as you want to make it. When I was at Fordham, and Tony and I are the exception, we met on Twitter probably in 2012, 2013. There are very few ways for you to meet people unless it's at like a competition, be it Tulane, and even then you're preparing, for your stuff. So it's really hard to really make that many contacts. I speak to a lot of people, just people reach out, people are go-getters. And I try to connect these people as best as I can. And 6 of them, leaders at various sports law societies across the country, UNH, where Professor McCann, his sports law program, Florida, Loyola, and Florida State, their leadership of those societies are creating a platform for people to publish, to be on podcasts, to kind of do their own thing. I think it's essentially trying to function like a Google. It's kind of your one-stop shop. So Stephanie, your blog could go there, or Emma, I know you're trying to start a podcast. That can be the source where you would go to for student created content. So if anybody wants it, I'm sure I can send it out. If Jake was here, I'm sure he could have emailed it. That would have been so much
Just
easier.
do the group me in the chat.
You have it. You put it in the chat, Jason?
Yeah, so for anyone trying to join, you should be able to. It's a public group. And the links
Excellent.
to the Twitter and LinkedIn will be available there.
Excellent. So that being said, I'm on Twitter, on Instagram at Sports Law Lost. My DMs are open if you have any questions, just like the ones that came up today. Great questions, team. I'm always happy to oblige.
Awesome. Thank you guys so much.
Thank you very much.
Thank you, Stephanie.
Thanks, guys. Have a good one.